Go over Chapter 5's brief hypotheticals with you. So I will start those for you to see. There's 10 under the brief hypotheticals. So the first one, Cheryl stands in front of her home with a bullhorn shouting that her neighbor Karen has just been released from prison for child molestation. Cheryl knows the statement's false. Under what legal theory may Karen recover damages from Cheryl? So in this case, this would be slander, right? Because slander is something that you say out loud. Libel is something that's written or something that is lasting. So maybe a newscast or something like that could still be considered libel. All right. The members of the City High soccer team have been training with Charlie, a personal trainer, for several years. Oscar, the soccer coach, tells the team members that they must train with Raul now and that they will be kicked off the team if they continue training with Charlie. All of Charlie's clients immediately stop training with Charlie. Oscar has committed what? And in this case, I'm going to go with wrongful interference with a business relationship. Conversion is a little bit of a different beast. So conversion is when, let me give you an example. If you took your dry cleaning in to have someone dry clean your clothes for you and they gave your clothes to somebody else by mistake, that would be conversion. Peter rents an apartment in a building owned by Roscoe. The sidewalks around the apartment building are in poor repair. Many areas of the walks have been raised by tree roots over the years and are rutted and uneven. In some places, the discrepancy in height is as much as 2 inches. Roscoe, what? He has a duty to fix the sidewalks. So in most municipalities, the sidewalk in front of your building is something that you're responsible for, the upkeep, shoveling, and all of that kind of stuff. So you should fix that. Louisa, in a hurry to get to a business law class on time, backs out of her garage without taking the usual care. Tony's car is parked in the driveway and Louisa runs into it, causing $2,500 worth of damage to the car. Tony may be able to prevail in a lawsuit against Louisa for negligence because she breached her duty of care, which requires her to act as a reasonable person, not be in a hurry, be planful, all those kinds of good things. All right. Bailey is driving her friend Sarah to the movies. Bailey loses control of the car and crashes into a fence. The vehicle's airbags deploy, and both Sarah and Bailey are emotionally shaken but not physically injured in the accident. Sarah threatens to sue Bailey for negligence. Sarah's lawsuit is likely to be what? And I hate when I read something and then don't pay attention. I am thinking unsuccessful because Sarah was not injured, if I remember this one correctly. So I'm trying to read it. Sometimes my brain goes blank. All right. While Mark, Cal, and Brian are snowboarding, they ignore numerous posted warning signs that they indicate that they have left the marked trail and are entering dangerous territory. The boys become lost and a helicopter is sent to rescue them. On the way to the mountain, the helicopter's blade severs a nearby town's main electrical cable. Electricity to the town is cut off for several days. Ethel, an elderly woman, dies of hypothermia due to the lack of heat in her apartment. The boys' negligence in ignoring the warning signs is what? So this is a really bad day. But in this case, it's not the proximate cause of Ethel's death. It is the causation, in fact, because it really did cause it, but it's not something that a person would actually predict would happen if they went off the trail. So it's not like they intended that consequence to happen. Michelle builds a shed in her backyard, but the assessment of her yard's borders is incorrect. Consequently, part of her shed sits in her neighbor Mark's yard. Michelle has committed what? This would be trespass to land. Similar to personal property, because your land is your personal property, but it's specific to that. Again, not converges. Jason runs a company that uses explosives to demolish large buildings. His company is held to the standard of what? And this would be strict liability. So if anything happens, they're responsible, and there's no really two ifs, ands, or buts about it because of the explosive nature, and they know that they're moving explosives. George is at a concert and accidentally bumps into Carl, causing him to spill his drink. Carl threatens to beat George to a pulp and moves towards him, but he is quickly restrained by friends. George may sue Carl for the tort of, he threatened. So I think that's assault. Yes, that was a good guess. So it's the threatening part that brings into assault. Battery is the physicalness of it. Virgil's hair salon runs an ad in the paper that claims that its main competitor, Crystal Cuts, uses products that are cruel to animals and damaging to clients' hair. As a result of these false claims, Crystal Cuts sees a marked decrease in clientele. Virgil has committed slander of quality. And for sure, it was in paper, so then it could be liable because it was written. But in this case, she's really talking a lot of smack about the quality, so that's where the slander of quality comes into play. All right. So now let's take a look at 6. Analyze legal reasoning. Three of these. Quality Inns International, Inc. announces a new chain of economy hotels to be marked under the name McSleep Inns. McDonald's Corp. Spends approximately $1 billion in advertising each year to ensure that the vast majority of Americans are familiar with its logo and its Mc products. McDonald's filed a lawsuit seeking an injunction preventing Quality Inns from using the prefix Mc. McDonald's claimed that the use of names McSleep infringed on the McDonald's family of trademarks characterized by the prefix Mick, attached to a generic term. Quality Inns claim that Mick has come to a generic use as a prefix, and that McDonald's has no trademark rights to the prefix itself. The court most likely found that Quality Inns' use of the prefix Mick clearly infringed, and it infringed because consumers were likely to be confused. Not because they were competitors, they don't have to be, but because they were confused. You might think, oh, maybe McDonald's owns that, or it's approved by McDonald's, or it's licensed through McDonald's, or something like that, and it's not. James Smith owned Michigan Document Services, Inc., MDS. MDS produced course packs for university professors and sold them directly to students. Smith did not obtain the copyright owner's permission to reproduce copyrighted materials in the course packs. Because MDS did not pay royalties to the copyright owners and sold the course packs for more than the cost of producing them, MDS earned a significant profit from the sales. Princeton University Press filed a lawsuit in federal district court alleging copyright infringement. MDS claimed that the course packs were covered under the fair use doctrine. The court most likely found that the reproduction of the material was what? Well, it's not fair use for sure, because they were making money on it. If you used it for your own personal, you made a copy, let's say you're doing a research, then it would be fair use. But they did profit from it, right? Which affected the potential market for the copyrighted works. So that is the answer. The third one, Jarvis Metals developed a new, more efficient method for smelting iron ore. The company was granted a patent from the U.S. Patent and Trademark Office for this method. After the patent was granted, Star Iron Works began using a method that was, for the most part, the same as Jarvis's process. Star process, however, used different methods at the very beginning and at the end of the process. Jarvis sued Star for patent infringement because of the very close resemblance of Star's process to Jarvis's, which the following is correct. In this case, Jarvis cannot recover from Star because infringement on a patented process only exists when all of the steps of the process are copied. So they all have to be copied. Okay? So that is the end of chapters 5 and 6.